Hello and welcome to this episode of Inside the Courtroom, the Senzo Meyiwa Wrap trial. I'm Mnisi. Now, the second term has kicked off and the trial is yet to resume. And this is because Advocate Charles Mnisi, the new lawyer for accused number one, Muzi Sibiya, is still not ready to proceed after being given over 2 months to go through the court record. Let's unpack how we got to this point. In December last year, Thulani Mngomezulu, who was representing accused number one, passed away, leaving Muzi Sibiya to now find a new lawyer. Mngomezulu was Sibiya's third lawyer in this case. He had previously been represented by Tsepo Tobani and Sipho Ramosipele before Mngomezulu took over his legal representation in the trial within a trial. In January, Sibiya told the court that he had now appointed the lawyer for accused number 3, Advocate Charles Mnisi, to defend him. At the time, Mnisi was given nearly 2 weeks to go through what we knew then to be 40,000 pages of the court record. He came back on the 3rd of February and said this to the court.
Fortunately, not in a position to proceed because I am not yet done with my preparation. The time that I had, it was almost like a week and 2 days, was very limited compared to the amount of work and the scope that I need to cover, my lord. I am here, therefore, to request that the matter be further adjourned for some reasonable time to enable me to proceed with the perusal of the record and other preparation which are necessary in the circumstances, my lord.
Judge Mokgwatleng tried to establish how much time Mnisi needed.
So how far are you? Are you saying you don't know?
I'm pushing, my lord.
Yeah, but how far are you? This record, how many pages does it have?
I don't even count the pages, my lord. I don't want to lie.
Pages when you have the whole record before you, sir.
Excuse me, my lord.
I thought you have the whole record before you.
Yes, but what I'm saying, my lord, is I haven't numbered the pages, maybe from page number one.
No, the pages are numbered for you.
The state told the court that the record was made up of 42,000 pages.
I don't even count the number of pages that I'm reading. For instance, when we would sit like today, maybe the evidence will go up to page 90. You take that volume, you go through it, then you put it there. You take the volume that, maybe you take the volume that is going to do with the evidence of the following day, then you do that, my lord. So I don't say today I've read up to page 50, then tomorrow I'm going to read from page 51 up to page 90, from page 91 up to page... I don't know at what page am I, my lord, but I can say...
How is it possible for counsel to read a record and you don't know? I'm on page 38,025. You just read.
Because the pages, my lord, are not numbered in the sequence that has been presented to court. The record does not go from page 1 up to page 45,000.
What does it do?
It goes from page 1 up to page 50.
And then?
Probably the following day it goes from page 1 up to page 70.
Right.
The other day it goes from page 1 up to page 90.
Yes,
the other day it goes from page 1 up to page 140. So I don't say today I've read from page 1 up to page 19. Then the following day I say, no, now this is page number 91. 91 up to page 150.
Mnisi said he understood that there are pages that had no bearing on accused number one. He also told the court that he still needed to consult with Sibiya on a number of issues.
So how many days, years, months?
Was looking at my diary, my lord, the pace at which at least I am trying to do things, or I am doing things. I'm looking on the date of the 24th of February. Yes. Which will be exactly 3 weeks from now. Ne? Yeah. That will be exactly 3 weeks from now, my lord. I think I can, and with the confidence, say that I would, unless something else happen, but with this date, I may come with a certain degree of confidence and tell the court that I will be ready to proceed.
Now, you must tell me, when do you think you'll be ready?
It's very difficult, my lord. It's very difficult. You never are ready up until such time that the matter starts. It's very difficult to say, I'll be ready on this date.
He gave a breakdown of what he needed to do in the 3 weeks that he had requested.
I need to be very sincere with the court. It's not like I'm reading I'm reading a billet dog. I'm reading evidence, my lord. That I need to compare and contrast. That I need to formulate arguments. That I need to take notes on. That I also need to write like nota bene. Go and refer to page all this and this and this and in some instances, my lord, whilst reading, I also go to authorities, go to do case research and relevant authorities. It's not like it's a smooth sail. Somebody is lying on his couch and reading a novel. This is a different ball game altogether, my lord. And the reason why I'm simply doing that, my lord, I don't want at the end of it all an argument to be raised that Mr. Sibiya did not enjoy a fair trial because the degree of preparedness on those who were representing him were found wanting. I don't want to be party to that argument, my lord. So I would therefore implore the court to find it in his wisdom that I definitely do need another extended period of preparation, but as I'm saying, the 24th of February, there's a very high likelihood, a very high probability that I may come and tell the court that I'm ready to proceed and indeed proceed, my lord.
The court doubled the number of weeks requested.
You know what I'm going to do?
Yes, my
I'm
lord.
going to give you 6 weeks.
I really appreciate it.
No, just listen to me.
Yes.
You know, I've gone through all the law
Yes, ma'am.
in this country and even overseas. Your client has a right to be represented by a competent counsel
Yes, my
who
lord.
is well informed and well prepared,
Yes, my lord.
right? But you see, you say you want further 3 weeks. I'm going to double it and make it 6 weeks.
The state and other defense lawyers agreed with Mnisi being given more time. Advocate Mshololo even suggested he be given the rest of the court's term.
My lord, since Advocate Mnisi indicated that on the 24th he may be ready or he may not be ready, my lord, I suggest that he be given a further period up until he can say he will be ready on that day to come and proceed. I agree with his lordship to give him 6 months or more. 6 weeks or more until the end of the term, which will be ending on the 29th of March, when he will be ready to come and proceed. I'm saying this, my lord, because we all have practices. We have to go and make commitments. We cannot afford to go and come back on the 4th to hear whether we will be proceeding or not. So if he's given a further opportunity, the entire time, my lord, so that we can go back to our practices and work whilst he's going through the record, then we come back the next time, everyone will be ready to proceed. That's my submission, my lord.
The court granted the request, postponing the matter to the 14th of April, making this a postponement of over 2 months. But the day finally came, and this is what Mnisi told the court.
My lord, I've done the best that I can. Actually, my life, if I were to put it, actually came to a standstill. Your life? Yes. I had to concentrate, I had to take all the time, do everything in relation to this case, my lord. Just on a very light note. I'm saying on a very light note.
Light note, yeah.
Yes.
You say it took over your life.
I'm not meaning dying.
No, fine.
Yes.
I understand.
Yes. On a very light note, my lord, I had to. I was supposed to go around the 2 oceans last week Saturday, and I had to forfeit my registration because I had no other option but to concentrate on this case. However, despite my fervent efforts,
But
I,
you took the brief, you know what it entails.
yes, my lord. But on the same breath, my lord, on the same breath, the court would also be aware that it is the state, and we confirmed with the state that the amount of work that I needed to cover there was almost more than 40,000 pages.
I've read, let me tell you,
Yes,
I've read all that,
yes.
that record.
Thank you, my lord.
All of it.
Yes,
You can phone my wife and my
yes,
children.
yes, my lord.
I've read it.
But with me, my lord, and I'm not trying to argue with the court, with me is not only reading,
Yeah,
it's to read
yeah,
and to analyze,
yes,
compare and contrast,
yes.
and to formulate my argument
Yes.
in respect of the cross-examination, in respect of the forthcoming cross-examination, my lord.
Mnisi was asked where he was going with this.
Are you saying you're not ready to
I'm
Comments?
not ready, my lord, to proceed. I'm not ready, my lord. Otherwise, if I had to come here and tell the court that I am ready, that will be an injustice to Mr. Sibiya. I would therefore request, my lord, a further postponement of this case. And I will continue to prepare. Come that date, I'll come and tell this court that I'm ready or I'm not ready. I'm very cautious. I will be very cautious this time, my lord, because last time I remember I told this court that come sun or shine, I would be ready today. That simply meant that I underestimated the amount of work and the amount of documents that I had to be content with. But the work that I needed to cover was just too voluminous, man.
The judge was simply not impressed.
You know what surprises me?
Everything. It's
You know what
very
surprises
tedious.
me?
Yes, mother.
You started this case with my predecessor, Judge Maumela, is that not so?
Yes, mother.
Yeah.
Yes.
And then you've been continuing
Yes.
and being continuously in this trial.
Yes.
And you are aware of all the evidence that has been led. And you know what? I also bent backwards. I allowed every advocate to cross-examine whomever. Didn't I do that, Mr. For instance, even advocates whose clients were not accused of having made confessions, you cross-examined. Mr. Nqumalo cross-examined. The late Ngomezulu cross-examined. Mr. Mshololo also cross-examined. Because you, as a group, you said to me, you're defending these people as a group. And you yourself, Mr. Mnisi, you cross-examined every witness, even if that witness never referred to your client in evidence. You did that.
The state did not oppose this request, but raised the need to expedite the matter.
This matter has got to be finalized. Brigadier Gininda has been in the witness box, I think, since November. It's now, 6 months in the witness box. It's unfair on him. His other professional duties are on hold. And it is in the interest of justice that at some point that his cross-examination should be finalized. But balancing the scales, my lord, we are not in a position to, to object to the request. Safe to say that we also express our frustration. The court is correct. The cross-examination has been prolix in this matter. If one, for instance, looks at the evidence of Sergeant Musiya, just a witness who came on the scene, just collected the exhibits.
It's
but
about 2,000 pages.
But his cross-examination went on for weeks and weeks.
The judge called it an abuse of the system.
Section 35(5) A, B, C, all those sections, they are not immutable. You can't abuse the system and then rely on the fact that the Constitution says you have to have a fair trial. The fair trial, like I quoted the case of King, this State versus King, Harams, I forgot that case.
Yes. Yes.
Where they say fairness must also be accorded to the state.
He granted Mnisi a final postponement.
It surprises me an advocate who's experienced as Mr. Mnisi can't read 40,000 pages in 2 months. Please. Surprises me. I'm going to accord the final postponement. And if you're not ready on this postponement, then your client will have to intercede on your behalf. And the final postponement, I can only give you up to Tuesday.
Mnisi instead hit back with a threat to withdraw.
If the court is saying that I should come next week ready to proceed with the
Yes.
matter,
Why not?
then I'm going to request that I be excused from
No,
representing
fine.
accused number
You
one,
can say
because
that
I
on
can't
Tuesday.
do that.
You can say that
Thank
on
you.
Tuesday.
Yes.
But this case is postponed to Tuesday. You said the date is about
22nd, Malord.
22nd. Mr. Mnisi, you have had enough, more than enough time. 2 months and 3 weeks. That's what we accorded you. It's a postponement. And you have been in this trial since when my predecessor, Judge Maumela, was seized with the matter. And every day you were listening to evidence which was adduced. It's not like you're a new counsel coming into the matter cold.
The matter was postponed to Tuesday. Mnisi's request for the matter to be postponed attracted commentary on various platforms. Newzroom Afrika also asked for a reaction from Judges Matter on this development.
Well, in this case, it was quite correct for Judge Mokwatleng to essentially read the Riot Act to Advocate Mnisi to say he must either come next week Tuesday being prepared for the trial to run, or there must be other means that are devised for the case to run. But this is again another common trend where we're seeing people on the day of the court case, they change lawyers, or sometimes the lawyers say that they are not ready. It is unacceptable, and in fact, it is in some ways unethical for a lawyer to wait until 2 months have gone by, 3 months have gone by, and say that they are not ready to proceed in a case that they have been involved for well over 3 years. Again, it is something that unfortunately judges or magistrates are really limited in terms of the kinds of interventions that can be made. But perhaps it is time that the legal profession should also start speaking out in some of these cases, because like I said, some of these points are because the lawyers involved are taking really unmeritorious points in order to delay proceedings. And that for us is a concern, and the legal community should really start speaking about it.
Let's take a quick ad break, and when we come back, our legal analyst, Mpumelelo Zigalala, helps us make sense of what has happened and what's to come in the trial. Stay tuned. Welcome back. Let's talk now to legal analyst Mpumelelo Zigalala. Mpumelelo, thank you so much for your time. Appreciate it. You know, what appears to be coming from Advocate Mnisi lacks detail in the sense that he does not indicate how far he is and what still needs to be covered. Also, does not tell the court how much time he needs. Surely there's no judge that would allow a postponement indefinitely.
Greetings to you and also to your viewers. You're quite right on that one. Remember that when the judge is making this assessment, he's not doing it in the air. He's controlled or is guided by the Criminal Procedure Act. Section 346, capital A, if I'm not mistaken, that says if you're assessing whether there are unreasonable delays, you need to know the intricate details of what those delays are, who is the cause of the delay, what can be done in order to avoid it. So important information like the number of pages you've read, what is still missing, is there anything else that you would like the court to take into consideration? What points that must be put on record so that if another person were to assess whether this matter was handled appropriately, those are the type of information they would need to deal with. And unfortunately, that's what we don't have. Even a rough idea to say, I've gone through half of the transcripts or 90% of the transcripts. I've consulted with my client. This is what I'm finding. And this is the type of difficulties which I'm facing. This information which is required in order for the judge to make an informed decision of saying that is the delay reasonable or not, and to make an appropriate ruling after that.
And I mean, when he came to court in February, he had indicated that he needed about 3 weeks, and that should have been fine. But again, there are no specifics in terms of what went on during that time and certainly where we're going.
And that's the inquiry which is required, not as a best practice, but as a matter of law. That's what the Criminal Procedure Act tells us to do. So we need to come back and say, I've read through the number of transcripts, I've consulted with my client, there are certain things in which we're missing. If, for example, the scenario was, I've tried to consult, due to my client being behind bars, I'm not being able to or found time in order to be able to do that. Or when we do find time, we're interrupted or given a limited space of time in order for us to consult. That would be a different story altogether. But even that being said, we then need to come back and say to the court, these are the difficulties which I'm facing. So when you are making your assessment, take those into consideration to determine whether are we delaying this measure deliberately, or is it due to circumstances beyond our control, and what type of intervention is required so that at the end of the day, this measure is done and dusted within the record time as prescribed by our Constitution.
Now, he's been given over 2 months to go through this court record. And at this point, obviously, no indication of how far he's gone. But also, how long does it really take? As somebody who's practicing, just let us in on how long it takes. And would a 2-month postponement be enough?
I think if the 2-month postponement is going to be the reading of the transcript, I would say yes. Remember, when you are reading a transcript, it's not as if you're reading a book or a novel. So the spacing in between the lines has been extended one. And basically what you are reading, any person who's going to make or make a submission in court, that particular sentence or line is going to be attached to them, and then you simply move on to another one. So in terms of reading the record and what is written or what is required there, it shouldn't take that much. Maybe a month or so would have been done. But the most important part, and the part which maybe I would have thought that much of the time would be invested in, is the one of saying, let me develop a legal strategy for my client. Let me go and consult with my client extensively so that I'm able to determine what type of legal strategy is going to be required. And then the second assessment is, in the witnesses that have been called now and the evidence that is already in the hands of the court, is there anything else that I would like to add or anything in which I would like to dispute? If that's the case, let me concentrate on making those applications to recall those witnesses so that we're able to put a proper, comprehensive, and full defense of the accused so that we're able to defend their legal interests adequately. So all this time, if from the time in which they took a break up until now, was purely concentrated on reading the record, then I would say he's not going to be ready on the next occasion because he still needs to consult, still needs to do some research and do this assessment so that he's able to stand up in court and say, I'm protecting the legal interests of my client.
But there's also the benefits of, him having been in the case even before Judge Ratha.
And that should be able to assist or help him because he would know the context in which the evidence was stated in. He would know the context in which the utterances were stated in. Unlike someone who's never been in that court, they don't even know where the source of the conversation would have been about. If there's any dispute about whether evidence should be admitted or not, they would know very well and be able to come to the session to say, yes, we've been able to determine what is there and we agree with it or we don't agree with it. Or if there's a difference or maybe a change in the legal strategy being adopted, then all those processes would have been done adequately. So it is an added advantage to him, and it is an advantage that should have assisted him to be able to finish this matter or reading or preparing for this matter in record time.
The court has given him until this coming Tuesday to make sure that he adequately prepares himself. But in retaliation, one might say, he threatens to pull out of the case. Would that amount to misconduct?
Well, it can, depending on how he's able to defend it. At the end of the day, the paramount interest is that of the accused, and if you're not ready enough or prepared enough to be able to prevent that legal interest, then at the end of the day, unfortunately, you can't be able to do so. But at the same time, you can't threaten the court or hold the court in ransom and say, if you don't give me enough time, I'm going to pull out, knowing very well the type of difficulties which are going to be there in finding another legal practitioner, allowing that legal practitioner to get enough time in order to read the transcripts, all those things which are attached to the normal process. But if certainly there's something untoward that has taken place, I'm sure that just one letter from the judge to the LPC, a full investigation would take place. And I don't think there's any practitioner who's practicing who would want that type of investigation to be directed towards them.
But ordinarily, is that how you would deal with situations that when you don't get what you want, you threaten to pull out?
No, not at all. In fact, maybe the most prudent thing to do in this matter would be to say this. If maybe by halfway in which you are given time, you can then be able to see that I won't be able to finish, a simple courtesy letter or an email to the other party and also to the judge would assist to say, let me update you as to the progress of what is happening. Let me update you as to the type of problems in which I'm facing, not to spring on the last day or the day in which we are supposed to start, issues which are now preventing you from moving forward, because all that we're trying to do is making sure that the diaries or the availability of all the practitioners is aligned. Certainly don't waste resources by allocating time which is not going to be utilized. Court time is very precious and should be used very sparingly and adequately and productively so that you're able to move forward with the number of cases that we have. So if you're able to update them as you go along, then it makes your story a credible one when you say you're not ready, because the receiving party will then say, yes, we've always been updated as to what the issues are. We are a reasonable practitioner in your shoes would have experienced the same issues. So we can purely understand that the circumstances which are beyond your control. Now, to keep quiet and only state the issues in which you are facing on the last minute and then say in defense, I'm going to pull out is something which should not be allowed and something which I think the LPC would not want.
Section 35 of the Constitution, the right to a fair trial. The judge even quoting a judgment that elaborates on this point, that it does not only apply to the accused persons. There are people that have an interest in this matter who also should be afforded the same right.
Definitely. And those people are yes, they accused themselves. You also have the NPA, which is just as worried. And lastly, it's the victims. They need answers. They want to know what happened to their loved one. They need to find justice in the form of a person who has caused them this hardship to be punished adequately. Now, if you are going to delay, the quality and the quantity of the evidence is going to diminish, making it difficult for the NPA to prove their case, and also making it difficult for you as a defense to be able to defend yourself adequately. So it is in the interest of every stakeholder that is involved to make sure that we're able to start and finish within the shortest or the reasonable time which is available. And if there are going to be signs that that particular time is being wasted once in a while, then definitely the court should be able to step in and say, please, can you please pull up your socks? What is at stake here is much more greater than us, much more greater than the sitting which is happening here. We're trying to find out the truth in order for the soul of the deceased to rest well. So if you're going to delay us, then definitely we're not going to take kindly to it.
And what I find interesting about the conversation on fair trial is the fact that, like you point out, the accused, their fate clings onto the conclusion of this trial. Their families want this matter to end, and they want to know what the verdict will be.
Definitely, it's a point of saying that I've already suffered as the victim with the loss of my loved ones. Now, the only thing in which I need closure on is to know what happened, what caused it to happen, who were the instrumental individual in causing it to happen, but most importantly, what was their motive? I need to understand that. It's part of closure, it's part of healing. And if we're going to have a matter that happened more than a decade ago, being still discussed in our courts to this day, then it does cast a bit of aspersion in terms of the way in which our law enforcement agencies are working, the way in which our courts are working, the way in which the NPA is working. All those things at the end of the day are going to cause problems, and definitely the judge would not want any of those delays to be attributed to him. So all the legal practitioners that are there should be able to understand that and work towards making sure that the truth is being unraveled, but most importantly, while protecting the interests of the accused in the matter.
Mpumelelo, the judge also complaining about the issue of double booking, where some lawyers not showing up to court because they have other matters, saying that in fact is not allowed. And if one looks at, the matter going forward, and for the sake of progress, there would have to be a level of cooperation amongst all the parties that are involved in this matter, right?
It did definitely. In fact, it's very important for that for all the practitioners to be in sync when it comes to the availability. In fact, double booking is an offense as per the LPC, and it's something in which they frown upon it. They do not want to entertain any individual practitioner that is going to double book themselves. So being available and be able to move on with the matter on the agreed date is something which is very important. Again, it comes back to the point that I had made earlier. If you're able to alert the legal practitioners to say that on this day I will not be ready or I'll be ready, then it allows everybody to rework their diaries, to then reprioritize the matter, then to be told on the day when you are ready and you've already allocated the next 3 weeks to a trial. Meanwhile, the trial is not going to proceed, mostly because they're also being paid by legal aid. Legal aid, if you have not provided any services whatsoever or postponements have taken place, they're not going to pay. So it's important that when those availability dates are being stated, everybody's available and ready to proceed. But most importantly, the double booking is something in which the court will not entertain because it is an offense on its own, as per the Legal Practice Council.
All right, that was legal analyst Mpumelelo Zikalala helping us make sense of everything that played out in court and what's still to come. The question now is, will Mnisi pull out or stay the course? That question will be answered on Tuesday when the matter returns to court. You and I will catch up again next week for an update on the Senzo Meyiwa murder trial. Until then, have a good one.